is yours.
Morning, Your Honor.
Good morning, sir.
My name is Keith Jordan. I am representing the appellants in this case. I have co-counsel who I'd like to introduce. Heather Tackett of the Robertson County Bar, Tom Smith of the Davidson County Bar, and Philip Robertson of the Davidson County Bar, and I am a member of the Williamson and Davidson County Bars.
Okay. I'm glad to have you with us today.
Thank you, Your Honor. And I would like to reserve 5 minutes.
5 minutes? Yes, sir.
Are you ready for me to proceed?
Yes, sir. Please proceed.
This is my third appearance before the court in this litigation.
We charge more. The more you come back, it's a multiplier. So there'll be a bill in the mail.
Thank you, Your Honor. But this is my first time representing the Slagle parties as the appellant. In 2017, this court was first presented this case in the form of an appeal from the Robertson County Chancery Court, which granted my client summary judgment in a case that, along with a companion case in Trousdale County, were the topics of separate appellate decisions, which for convenience sake I will refer to as Church of the Firstborn 1 and Church of the Firstborn 2. Church of the Firstborn 1 being the Trousdale matter, and Church of the Firstborn 2 being the Robertson County matter. It was decided by this court that Title II Robertson County properties of the Church of the Firstborn lay with the trustees of the unincorporated association church, and that the two corporate defendants lacked standing to assert title to those properties. The case was remanded for further consideration on one of Chancellor McMillan's 8 findings, which was determined to be a genuine issue of fact, namely whether the church was hierarchical or congregational with respect to ownership and control of church property. In November 2018, while the remand was still pending in Robertson County Chancery, certain individuals filed a complaint in the Robertson County Robertson County Court alleging membership in the church and claiming status as members for the same relief that they had requested on behalf of the Church of the Firstborn of Tennessee corporate entity. The two cases were consolidated, and the sole issue presented to a jury of 12 in a 5-day trial conducted in August 2019 was whether the church was hierarchical or congregational for the purpose of controlling and ownership of property.
Counsel, was there any objection made to posing the question in that manner? And is there any objection to the jury charge in this case, to the jury verdict form in this case? Was there any, and it seems like that becomes a thread that gets unraveled in this case in terms of Chancellor Dean's understanding of the inadequacy of that determination. Was there any objection made to that form or to the jury charge in this case?
The jury charge and the jury form were both discussed with Chancellor McMillan prior to the opening of trial and were agreed to by counsel, and the jury charge and the verdict form were the ones that were submitted to the jury that had been discussed prior to the opening of trial. The resulting verdict was that the church was hierarchical and was approved by the presiding judge as the 13th juror, who also entertained all post-trial motions, which were denied, and therefore the verdict was rendered final. The appellants filed a motion for partial summary judgment based on that verdict, and on November 2020, Chancellor McMillan entered his order granting partial summary judgment, referring the case to a special master for a report and recommendation on the issue of damages. That report was issued in August 2022. 6 weeks later, the appellants filed an objection to the special master's report and added to that filing a motion to reconsider the 2020 summary judgment order entered by the previous chancellor. It was 3 years after trial and 2 years after, more than 2 years after the summary judgment order was entered by Chancellor McMillan. Our first matter, which we would like the court to look at, was whether or not that motion should ever have been presented in the form it was presented, and whether or not it should have been entertained by the chancellor. In filing their motion to reconsider, no citation to a rule of civil procedure was identified, which means that it was a baseless motion. Now, there are motions to alter or amend. There are motions to revise, but there's no such thing as a motion to reconsider. And if you look at it as a motion to alter, amend, or as a motion to revise, that motion should have been made within 30 days after the entry of the order of summary judgment. By comparison, in 2024, Chancellor Dean entered a summary judgment order, which was felt by the appellants in this case to have problems. We filed 2 matters within 30 days, an objection and a motion to alter or amend, which gave Chancellor Dean the opportunity to look at what he had entered, and he chose to go on ahead and make a new order, which more, I think, reflected what was intended to be his ruling on the summary judgment motion that was the subject of that order. The appellants, in failing to file a motion to alter or amend, I think waived the opportunity to bring to Chancellor McMillan's attention any perceived inadequacies in the 2020 summary judgment order. And now they're asking this court, or actually they asked Chancellor Dean to step in and change an order that by that point had been rendered 2 years old. And they're asking this court to basically find that they had every right to do so when the rules of civil procedure gave them no such entry point to do so.
He not only changed the order, he sort of undid the jury verdict too,
On a separate
right?
motion that was filed in December. Because having, I think, improperly ruled on their motion to reconsider, they then filed a motion in December of 2022 asking the court to vacate the jury verdict, and in order to do so, asked him to certify his familiarity with the underlying trial, which was a 5-day trial, take on the position of a substitute judge, and then rule as a 13th juror, which, in our opinion, was something he was not able to do. He didn't. Rule 63, which is the rule of civil procedure, which deals with substitute judges, it's pretty clear. If a judge cannot complete a trial or be in a position to entertain post-trial motions, that judge can step in, certify his familiarity with the case, and take on the role of a 13th juror for that trial. Chancellor McMillan was able to complete the trial. Chancellor McMillan was able to rule on the post-trial motions. Once those post-trial motions were ruled on by Chancellor McMillan, that verdict became final. There is no such thing in Tennessee law as a 14th juror, and yet that is the role that Chancellor Dean apparently took on when he chose to rule on this.
When the new chancellor came in, he essentially sort of steps into the shoes of the old chancellor for purposes of continuing everything.
Yes.
Now, decisions by a chancellor aren't really final until, that's okay, we'll keep going.
Okay, thank you.
Decisions by a chancellor aren't really final until the case is final. Can always go back and change its mind. Does that allow a substitute chancellor to go back and change things that the original chancellor did before the case became final?
I guess it would depend on what matter it is that the chancellor's trying to step in. I would say in this case, no. First, because the basis on which they asked the chancellor to step in, which was that the order was, the initial summary judgment order was inadequate, was a matter they could have raised and I think waived by failing to file a motion to alter amend at the time that summary judgment order was entered. And secondarily, with respect to the trial, again, I think the rules of civil procedure are fairly clear. The matter referred to the jury was a fact question, whether or not the church was, for purposes of ownership and control of property, hierarchical or congregational.
And that's what
Was
the Court of Appeals ordered that and said
Right.
it was a fact question.
Said it was a fact question.
So that's the rule of the case.
Right, and the jury makes fact decisions. That matter was referred to a jury. The jury considered the factual issue and came down with a verdict. Once that verdict was entered, the presiding judge, as the 13th juror, is able to, if he feels that the jury verdict was against the weight of the evidence, he can order a new trial. If he determines that the law as applied to the facts can only result in a directed verdict, he can enter a judgment NOV. Those are done in post-trial motions. Once those post-trial motions have been ruled on, the verdict becomes final. It's appealable. It's appealable. But for purposes of before a trial judge, the matter is final.
But as I understand it, I'm sorry I'm taking more
No,
time here.
no.
No,
But as I understand it, Chancellor Dean didn't say the jury verdict was null and, well, he did, but he didn't call in a new jury. He
No, he
just
didn't.
decided it in himself, right?
Right, and if it was a fact question, not a legal question, that matter had already been determined, because juries determine facts.
Okay, thank you.
All right, thank you, Mr. Jordan.
Thank you.
Good morning.
Good morning, Your Honors. My name is Tanya Austin. May it please the court. I'm here on behalf of the appellees. That includes all of the individuals that we've been referring to as the Brewer parties, the Church of the Firstborn of Tennessee, and that's what we've called the corporation, and also Dayspring Academy. May I begin?
Please, thank
Okay.
you.
Your Honors, this is a classic intra-church property dispute. This is not a contest between entities of a local, separate entities or a local parish and a parent church. The record's clear, there is one church at issue in this case, and all of the individual parties to this case all claim membership in the same independent congregational church that was formed in 1930. And the ultimate issue is which faction of this church gets to keep the property following the split.
Counsel, if I recall
Yes.
correctly from your brief, you used the comparison of the Catholic Church essentially as one church across multiple churches, but that seems almost definitionally a hierarchical church. I mean, you don't get more hierarchical than the Catholic Church in terms of analysis here. So I was in reading through your description of this relationship, how is this a congregational church? And how, if unless we if we take your approach, are we rendering the Catholic Church a congregational church?
Forgive me, Your Honor, I'm not sure if you might have mistaken my argument for the argument of the appellants. We have never taken the position that this church is anything like the Catholic Church. We've used the Catholic Church as a great example of a church that is a hierarchical church, and I believe the appellants made the point.
Well, isn't it one church, though? I mean, everybody's a member of one church, right? There's one universal Catholic Church, and people attend different parishes. And isn't that the same structure you're essentially saying exists here with this church, that there's 4 different churches that people go to, but it's really all one church, they're part of one religious body? And how would you distinguish the two then, given the description you're offering?
I understand the question now. I apologize, Your Honor. No, I think this is very, very different from the classic hierarchical church that you see like with the Catholic Church. First of all, there's one entity at issue here. This church had there was a White House location, at some points a New Deal location, there was a location, or still, the Hartsville location at the time of the split. There were just 2. These locations, these congregations, these sanctuaries had no independent identity of their own. They didn't have their own tax ID. They didn't have their own bank account. There was one bulletin that went out to these churches, one board of deacons, one elder overseer. They had pastors, one Little Buddies program. I mean, it was one church. I think it's even undisputed by Mr. Jordan in one of the hearings before Chancellor Dean when he asked, is this an intra-church dispute or an inter-church dispute? And he said, well, before the split, it was an intra-church dispute, meaning there's one church. It's not the same as a Catholic church where there is this overarching parent organization, and then there's these connections between the parent organization and these individual local parishes that have
Hasn't the
their
jury
own
made a
identity.
determination here? I mean, the jury was presented with the question of whether this court said it's a fact question, right or wrong, and that was essentially, send it back, it's a fact question, the jury determined. The jury says hierarchical, and opposing counsel says there was no objection raised to the jury verdict form or the jury charge. And isn't that definitive in terms of whether this is a hierarchical church or not?
Well, I think it's a great question, and it is the long history of this case and the multiple trips to the Court of Appeals. It has been an interesting journey, and I think what it comes down to is that first of all, when the Robertson County and the Trousdale County cases came to the Court of Appeals in, I think, 2015, 2016, with the decisions in 17, the posture before the court was that there were 2 summary judgment decisions decided by 2 different chancellors on essentially the same record, both coming to pretty different conclusions. One chancellor said that it was a congregational church with a standard practice of board control. The other one said that it was a hierarchical church where the board was the highest body in the hierarchy. So the court found there was, I think the only undisputed issue, according to the Court of Appeals at that point, was that the property is all owned by the church, that the trustees hold title for the church. Everything else was really disputed, specifically this question of, is it hierarchical or congregational? So when it went back to the trial court, following the finding that the attempted incorporation hadn't been successful, as Mr. Jordan mentioned, the Brewer parties then filed the claim in their capacity as members, and some of them also as trustees for the church, and then it proceeded to the jury trial. I think if we could look back on that with hindsight of 2020, there are definitely additional objections that would be made, although I will say there were lots of motions in limine leading up to that single issue trial to try to keep out some of the ecclesiastical issues that did make it into the proof.
But there's no objection to the form, right? I mean, in the thread here that Chancellor Dean seemed to pull on, and correct me if I'm wrong, but it seems like the thread that sort of unwove this garment is the Chancellor Dean looked at it and said, I don't think this jury verdict form was sufficiently nuanced. There's more complex questions here given the nature of this church, and you sort of phrased it in terms of a hybrid perhaps and in its nature, and property versus control and how that plays out. May be right on all of those things, let's say, but if there's no objection raised to the verdict form and the jury answers the question, on what basis is Chancellor Dean years later able to come in and sort of say, well, I don't think that jury verdict form was actually as nuanced as it should have been? And don't we have the answer to the question of whether it's hierarchical or congregational hybrid or whatever it is? And I'm trying to figure out how years later he can pull on that, the chancellor can pull on that thread? What's the route that procedurally gets him to undoing a jury verdict?
Well, I think there's two parts to the answer. First of all, it was a 5-day jury trial where the parties really fleshed out all of these factual issues that would have gone into the question of, is this church hierarchical or congregational? And notwithstanding that issue did go to the jury for a decision, along with a lot of evidence that was objected to along the way on many grounds, including the ecclesiastical extension doctrine. I believe multiple passages were read from the King James Bible to give context to these disputed bylaws that apparently Acts 3:1-6 gives the authority that the deacons were in charge of property according to appellants. And all of that went to the jury, all of that. When Chancellor Dean came on as the new chancellor, Rule 63 required him, even if we hadn't asked, it required him to go back and look. This was a multi-part case. There was a jury trial, but then a summary judgment. It didn't resolve everything. It was still ongoing. It's a lot like the cases we cited in our briefs about where part of a trial addressing one issue happened under one chancellor, and then the court needs to continue with the new chancellor. They have to certify their familiarity with the record to be able to say, nobody's going to be prejudiced if I proceed with this lawsuit. I understand what happened. I can build on it. So Chancellor Dean had to pause and look back at all of this and say, can I continue to build on these decisions? And what he found in, I think, going through the very painful process of several months of review of the trial court, all the briefing, the trial testimony, the exhibits, what really emerged from all of that is that there wasn't actually a dispute of fact as to whether the church was congregational or hierarchical. The parties agree on the church's history.
Didn't this court, though, make a determination that there was a genuine dispute of material fact? And this court made a determination in the previous round that there was a genuine dispute of material fact. What has changed that the chancellor is now saying, no, Court of Appeals, you got it? So not only did the previous chancellor get it wrong, but it seems like this court got it wrong in terms of its understanding that there was a genuine dispute of material fact in this case. What has changed such that the chancellor was not overstepping in reaching that conclusion?
I think the answer, the short answer is the factual record was more developed through the trial testimony, and there was also, I think, a lot more attention paid to what evidence is actually admissible for the purposes of addressing these issues, and that's something we went through in a lot of detail in the briefs. And a core issue of that is that these disputed bylaws are the main source of the I guess, authority of the Board of Deacons to have been in charge of property all of this time.
Is there inconsistent testimony about past practices in terms of operationally, though, in terms of control in this case? I mean, don't we have conflicts here in terms of how this was actually being run among people who were in leadership in this church?
Yes, Your Honor. I think the best way to describe this is that there are not disputes as to what actually happened. There is some testimony where people, if they want to paint with a broad brush, they'll say, well, the deacons always decided, or the deacons, we voted in pastures sometimes. But there are so many examples of where individual groups of members made decisions about property. They raised money, they bought it. The elder overseer acted sort of, I don't want to say behind the back of the Board of Deacons, but certainly without their permission and authority, and handled property things. The most recent property examples are huge property decisions made with the authority or the vote of the congregations, where I believe the Board of Deacons chairman said to the congregation, this is a democracy. This won't happen unless the congregation approves it. So it was a mixed bag.
And the jury decided that it was hierarchical.
Well,
I mean, how can Chancellor Dean, you said Rule 63 allows him to go back and familiarize himself with everything and build on it. He didn't build on it. He took a wrecking ball to it.
I think that
And what allows him to go back and undo everything years after these things were done?
Well, Rule 63 does give him that authority, because if he feels he can certify his familiarity with the record, then he absolutely can look at it and say, I can act as the 13th juror and I can reach a different conclusion. or he can say, I can't get comfortable with this, I need to order a new trial. What happened here is Chancellor Dean looked at all of it, got very comfortable, but saw fatal flaws with what the prior chancellor had allowed to go to the jury. But then he found that because it does not, these parties don't really dispute what happened. They don't dispute the church's history. They dispute these inferences that should be drawn from it. They take the same set of facts, the appellants do, and look at it and say, this is evidence of exclusive control by the board, whereas instead it's the lack of a standard practice, the disputes.
Did the
Sorry.
Brewer group go back and point these out to the chancellor, or did the chancellor come up with these himself?
I think it was a combination of both. I think these were our same arguments that we had presented to the trial court in the, at trial. What it comes down to.
So how many bites of the apple do you get?
Well, I think
That's
the
rhetorical,
bigger
I
issue-
guess. Never mind.
The bigger issue, I think that what's important to understand about what Chancellor Dean did is that he took a step back and he looked at, is it even possible for this church to be a hierarchical church? For it to be a hierarchical church, there needs to be some connection between multiple entities. Prior to the split, there was never even a hint or an argument that there were multiple churches here.
So
it was one church.
What I hear you saying is that Chancellor Dean looked back at the record, decided it was a more complicated question than is it just hierarchical or not. So that allows him to ignore the Court of Appeals decision that it was a question of fact as to whether it was hierarchical or not. And in effect, the chancellor could go back and make that decision for himself, undoing the jury.
Well, I think what he did was he went back and looked at the record with fresh eyes. Frankly, I think he had a better view of the record than what this court would have had in the 2015 appeal.
But the record is the record. You make the record and you appeal and you live with it.
Well, we were ordered to have a jury trial, and additional, the record was additionally fleshed out on that issue. But I'm running very close on time, so I just want to say this
We'll
really
give-
clearly, that what Chancellor Dean did was he took a step back and he looked at, his duty was to decide if he could get comfortable with this record or not. He went back and he looked and he said, this jury verdict can't stand for all of these evidentiary reasons. The ecclesiastical decision, I think it was a little deeper than just looking at the jury verdict form. And he said, but I don't think we need another jury trial because I don't see true disputes of fact. Looking at all of this globally.
Counsel, on that point, I'm struggling with that in terms of, you're saying, well, Chancellor got a better look at it, a better understanding of it. It's, maybe this court got it wrong. Maybe Chancellor Dean has it right and this court got it wrong, but in the last round. But isn't that the law of the case here? And the law of the case here is this is a fact question to be decided by the jury. It came up, there was a dispute about it, this court said, we think there's a genuine dispute of material fact. I mean, here in sort of this discussion, it sounds like there's at least disagreement among the leadership in terms of what the structure of this church was. And you refer to those as inferences, but they're factual inferences, right? So in terms of that discussion, I'm trying to figure out how we get past sort of the law of the case aspect of that. So let's assume the chancellor could revisit, and could he really go to the extent, even if he could revisit, of granting summary judgment in this case? And that seems to run in diametric opposition to the previous decision of this court.
My time's going to run
Oh,
out on mid-sentence.
You
but
can
may
have,
I
we gave
answer?
Mr. Jordan more time, we'll give you more time.
Thank you, Your Honor. Well, okay, so your question, Your Honor, is.
Law
how
of the
do we
case.
I'm sorry, the
Law of the case. Yeah, how do we get around law of the
on
case?
Issue of material fact. I think what it comes down to here too is that the jury verdict asked, again, wisdom of hindsight. I would now comfortably say that we should have phrased the question to the jury a little different. I agree with Chancellor Dean on this, that sending it to the jury with this singular question, is it hierarchical or congregational, it just doesn't answer enough questions. Knowing so the jury, again, with the setting aside all the evidentiary issues that went into that jury verdict, they found hierarchical. That tells the parties almost nothing for the sake of resolving this dispute. What that tells the world is that the church is hierarchical, but we don't have governing documents here. We don't have a hierarchical structure like what you see with the church, with like the Catholic Church, with the Presbyterian Church. There is absolutely nothing for the court to reference, to defer to help resolve this dispute. So if the finding that the church is hierarchical stands, that still doesn't mean that the Board of Deacons is the highest body within the church to make property decisions. So we're stuck. At that point, there is absolutely no way for the court to assist these parties in resolving the dispute because we have a hierarchy with no structure, with no rules, at least no undisputed rules.
Well, there is a structure, and there are allegedly rules, and if the chancellor sees that the evidence doesn't all fall in one way, doesn't that call for another trial?
Well, that's the thing. There are limits to what a jury can, there's limits to the court's jurisdiction as to what they can resolve with a dispute. So if, again, typically when you see a true dispute as to whether a church is hierarchical or congregational, it's going to be presented to the court in the context of two entities fighting over property. Saying, for example, I'm just going to come up with something, the First Presbyterian Church of Austin, Tennessee. If that church wants to disaffiliate from the Presbyterian Church, then the question becomes, is it hierarchical for the purposes of owning and controlling its property, meaning has it ceded its ownership or control to a hierarchy? This can also happen in cases that are not so clearly a hierarchy, such as, I think, the Jehovah's Witness. There's a lot of case law on that. You just don't see a true dispute of whether a church is hierarchical when it's a fight among members of that one church. Nobody's claiming to be part of a local parish of White House or a local parish of Hartsville. They're all fighting over all of it. So setting that aside, with the verdict of hierarchical, there are limits to what the court can do to resolve the dispute about, well, who within the hierarchy controls? Because if there's a hierarchical church, then the court is limited to deferring to the highest body in that hierarchy who makes property decisions. The court doesn't get to tell the congregation to vote or say what the decision should be. It's defer. You defer to the highest body in the hierarchy. Here, we have a dispute that there's a hierarchy at all. But assuming there is one, who in that hierarchy controls the property decisions? Obviously, the appellants say it has always been the Board of Deacons who had exclusive control over property, but that is not borne out in the facts. Instead, it is a mixed bag. Property decisions have been made a variety of ways over the 70-year history of this church, even before the split. That's what Chancellor Dean was looking for. Is there any admissible, credible evidence that the Board of Deacons was the exclusive body in control of property under any governing structure, whether it's a hierarchical church with the Board of Deacons as the highest body making those decisions, or a congregational church where there's a standard practice of the Board of Deacons making the decisions? Neither were present in the undisputed history and records of the church. The court's limited on what it can look at. Frankly, most of the testimony from trial really shouldn't be considered. There's case law, we've cited it to death in our briefs, that the court's limited in looking at questions like, if there's a genuine dispute as to whether the church is hierarchical or congregational, the court is extremely limited in what it can look at to decide that, because going too far will put you into ecclesiastical issues. And to accept the appellant's version of how we know the deacons were in charge, you have to look at their disputed bylaws. And when I urge the court strongly to look at what they refer to as their bylaws, it is a handwritten document with scribbles and half citations to biblical scripture, purportedly from the King James Version of the Bible, and they want to then give the court the text of that scripture from the King James Bible and tell you what it means. They want the court to adopt their interpretation of the Bible to say that the Board of Deacons was the body in control of property. And frankly, if you're familiar with the scripture they cite, then we shouldn't get into it, but the understood context of that does not even mean what they're asking the court to say it does. It's so far beyond the court's jurisdiction that it could be a textbook case of an ecclesiastical
In a nutshell,
violation.
what do you think we should look at, and how should we decide this case in a nutshell?
Well, that's a big question, but I think it really comes down to the structured analysis that the court is supposed to follow, and Chancellor McMillan should have followed years and years and years ago in deciding this case. And that starts with, if there's a question as to who gets this property, resolving this property dispute, the court has to understand its jurisdictional limits and start with looking at the deeds and the governing documents, and to see if those can answer the questions. A lot of times they do, especially in a true hierarchical church. The deeds are going to say, well, the property's titled in the name of the local parish, but the affiliation documents have said the Presbyterian church or the Catholic church actually gets to control the property. So if there's a split, the
Well,
parish can leave.
You're getting
you can't
off
keep the
into
property.
theoretical
Oh,
arguments again.
I apologize.
I want you to focus on what should we look at and how should we rule on the issues to put this to bed.
Well, I think that
Because
While the opinions
we can
were-
argue, we've been arguing for 20 years, and y'all are still arguing, and it's like you're on two different planets.
I agree, it does feel that way.
I want you to tell me what it is that this court should focus on, and on what basis should we rule, and how should we rule?
Okay, I think, yes, Your Honor, I think the court should focus on whether there is any evidence in the record to support a finding that this church is hierarchical. This court, the law of the case is that the St.
Okay,
Andrew
if we
factors.
find that it's not hierarchical,
Yes,
where do
sir.
we go from there?
Well, if a church doesn't have any factors of a hierarchical church, then it is, in essence, a congregational church. Congregational doesn't have to be something fancy, it just means governed within itself.
Okay,
And the
but
absence
you're
of that
arguing the
structure-
theories of hierarchy and
Sure.
and congregational again. What should we look at to rule, instead of arguing hierarchical and congregational?
I apologize that I was on a tangent. I am trying to answer that question. If the church is congregational, then the answer is simple. If the church is congregational, you have to look, is there a standard practice that says how this should be decided? And if there isn't, majority rule. And that's where Chancellor Dean landed. He didn't see any evidence of a hierarchy, and he didn't see any evidence that there was a standard practice of board control, even in a congregational church. Therefore, the default is that the majority rules, and that means the congregation needs to vote, and then they'll decide who keeps the property following this church split.
Anything further?
A lot further, but
Yeah. Any
I just
further
asked the court to affirm the trial court's
Further
decision.
questions?
Thank you so much for your time.
Thank you. All right. Mr. Jordan, we're welcome to hear what you have to say, but at the end, I would like for you to try to answer that same question that I posed to her.
I understand, Your Honor.
But present your argument as you deem appropriate.
Trying to sort of work through the threads of counsel's discussion with the court. I think there are probably about 3 matters that I would like to point out. First has to do with the role of the chancellor in reviewing matters that transpired under his predecessor judge. And the question was raised what Rule 63 is all about. And so I'm using my little internet machine here, and I'm going to try and point out what Rule 63 says. If a trial or hearing has been commenced and the judge is unable to proceed, another judge may proceed upon certifying familiarity with the record and determining that the proceedings in the case may be completed without prejudice to the parties. Then it goes on to say, in a trial without a jury, the judge can recall witnesses. The advisory commission comments are, the addition of this rule, which is similar to the federal version, is needed to cover the various situations where a judge starts but cannot complete a trial or hearing on post-trial proceedings. And then there's a further advisory comment. In jury trials, the substitute judge would be forced to recall witnesses in order to observe their demeanor due to Tennessee's 13th juror rule citing State v. Bibry, 858 Southwestern 2nd, 911, which was a 1993 decision. This is not a Rule 63 case. Chancellor Dean said he was familiar with the case, which is part of Rule 63. But the underlying trial was already over. The matter was concluded, final arguments had been made, the jury was charged, the jury made its decision, all under the auspices of the presiding trial judge, Chancellor McMillan. Post-trial motions were filed. They were briefed and argued and ruled on by Chancellor McMillan. This is not a Rule 63 case. We had a 13th juror. That was Chancellor McMillan. He approved the jury verdict. What Chancellor Dean is trying to be is an appellate judge. He's trying to go back and determine whether or not evidentiary rulings were appropriate, whether or not the charge was an adequate charge, whether or not counsel in its closing arguments had made appropriate or inappropriate arguments to the jury. That's not the role of a trial court. It's not the role of a 13th juror. That's the role of this court. This is not a Rule 63. He did not have the authority to do what he did. And they can claim he was a Rule 63 13th juror, but he wasn't. Because he took upon himself to review evidence and decide whether or not the rulings made by the presiding judge were the right ones, whether or not the charge was the correct one, and whether or not the arguments of counsel was appropriate, whether or not admissibility of certain evidence was correct or incorrect in a trial that was over. So he just didn't have that authority. So that, I think, is one matter that we would take issue with the appellees.
Counsel,
Yes.
if a trial court judge is stepping in and the matter is not final, and that trial judge believes that an error has occurred, why can't the trial judge correct it? And if they're looking at it and saying, you know what, this is not a final matter, and it wasn't a final matter, and in terms of there's not a final order in this case at this point, and if Chancellor Dean thought it was wrong, why couldn't he step into that role?
Well, he could. He could, if this were true Rule 63, he could have recalled witnesses. He could have brought in, like the rule said, other matters. He did not do that. He just simply ruled on it as if he were an appellate judge. I mean, that
You're
is-
saying he could have reopened proof,
Yes,
but he didn't.
but he did not. Rule 63 judge can do that. He did not. He just ruled on it as if he were a reviewing court. There were some discussions whether or not this is an inter-church or intra-church dispute. And I think, looking at what this court ruled on in Church of the Firstborn too, it's clear this is an inter-church, not intra-church dispute. In part, I think that's because there was a focus on the incorporation as opposed to the election that took place in November 2010. The proof was that this was an entity that had multiple congregations that had one governing overarching structure that was an elder overseer who handled spiritual matters, a board of deacons which handled the property and financial matters, and trustees that held title on behalf of the entity itself, no matter where the congregations were located.
When you say there was proof, would you agree that there was contested proof on that basis? That there was contrary proof in terms of what the parties are presenting in terms of how this actually worked in practice?
Yes, that's correct, but the jury made its finding. In November 2010, a letter was sent out by Pastor Roger Brewer to the members of only one congregation, the congregation located at White House. It said, we're having an election for a new board of deacons and a new church secretary for the White House congregation. Who's eligible to vote? Members who've been attending the White House congregation for over 50% of the year preceding the vote. We're going to meet at the Day Spring Academy Auditorium. We're all going to take a vote. And as a result of that vote, the White House Church elected a new board of deacons and new church secretary, not for the congregation as a whole, but for the White House Church. They're able to do that. I mean, this is America. The White House Church can elect its own officers, its own church secretary, its own board of deacons. And they can separate from the larger church, which is, in effect, what they did when they participated in that election and chose to do so. But the property remained titled to the unincorporated association. And when that faction incorporated themselves as the Church of the Firstborn of Tennessee and challenged title that was held by the trustees for the unincorporated association, this court said they lacked standing, that the trustees of the unincorporated association were not absorbed by that action. The entity known as Church of the Firstborn of Tennessee existed alongside the unincorporated association, and the trustees for the unincorporated association retained title. This court in 2017 recognized the trustees that they claim are trustees of the unincorporated association as trustees of the Church of the Firstborn of Tennessee. It was the election and participation in that election that was limited to only one congregation that led to the separation. And that separation set up a rival organization and made this an inter-church dispute over property. Elections have consequences. After that election, a letter was sent on January 24th, 2011. Now, this was not presented to the jury because it was post-split, but it is in the record. And this letter was signed by Roger Brewer, and it says, to the Robertson County Assessor, please use this letter as an official notice. The Church of the Firstborn, located at 3070 New Hall Road, Greenbrier, Tennessee, on 11/21/2010, elected a new Board of Deacons and Church Secretary. The offices are as follows, and it lists a Board of Deacons, lists a Board of Trustees, lists a Church Secretary, and lists a pastor, all of whom are different from those that were serving as Board of Deacons and Church Secretary for the larger entity. And then it goes on to say, please note, no other person has authority to make any change or conduct a transaction of any kind on behalf of the Church of the Firstborn. This includes any church property located in Robertson County. Church bylaws, and they're referring to their own bylaws because they adopted their own bylaws, are very specific regarding the process which must take place before any real property change or transaction can legally transpire. And it lists them. 51% majority vote by congregation located at 3070 New Hall Road, Greenbrier, Tennessee. Approval by a majority of the Board of Deacons listed above. approval by the pastor listed above. Only with proof of this process do the trustees have the authority to carry out the wishes of the Greenbrier Church of the Firstborn. The Greenbrier Church of the Firstborn had no title, any more than the Church of the Firstborn of Tennessee had title, as ruled by this court. They separated in November 2010. And this was what was presented to the jury, not this letter, but the facts of the separation, the facts of the election, the fact that a decision was made to separate the entity that was presiding in White House from the larger entity that had multiple congregations, and in the process try and take control of the property located in Robertson County that was titled to the larger entity.
Mr. Jordan, if you would try to wrap up and answer
Sure.
that one question that I asked.
What we would ask the court to do is to reinstate the summary judgment that was entered in 2020 by Chancellor McMillan based on the jury verdict and in consideration of his prior rulings that were the subject of this court's rulings in 2015, understanding that the composition of the Board of Deacons has changed over time, but the current Board of Deacons of the Unincorporated Association have been duly appointed by an elder overseer for the church as a whole. And by granting summary judgment, send this matter back to the trial court for consideration of damages. We've already had a hearing on damages. We already have a report of the special master making recommendations, and have Chancellor Dean consider those recommendations contained in the special master's report.
Thank you, Mr. Jordan and Ms. Austin, for your arguments. A very complicated case, very important case, and we will certainly give it our very best attention, and thank you for being here. That concludes today's docket.